Hi, everyone. This is immigration lawyer John Kasravi. Thank you for joining us for the podcast, episode 154 of the Immigration Lawyers Podcast, a division of the Immigration Lawyers Toolbox. So it's going to be a really cool episode. We have Angelo Paparelli. I'm sure you all know about him, one of the top immigration lawyers in the country, done a lot of writing, been in the game for decades. And I was going to have him and go through an interview like I typically do with the 10 questions. But a week before, our great colleague, a former immigration attorney and immigration tech guru, uh, Roman Zelechenko, did an interview with him on his podcast, GMI Rocket, which I recommend everyone visits to. It's focused on immigration tech, and he did a thorough biography of Angelo. So then I thought, why repeat things? Let's just talk about different things, what's going on in this practice and the like. And before the show started recording, we were talking. We just got into talking shop about immigration. I said, you know what? Let me just press record and we'll jump into it. So you're going to see the episode when it starts, it kind of really rapidly, we just start talking. And that's the reason for that. So I wanted you to be prepared for that. Now, a couple other notes I want to bring up. The Immigration Lawyers Toolbox, the monthly program, is happening where we educate and give CLE credits and updates on immigration and practice and all that, as well as the Mastermind Marketing. That's every month. But also the Champions for Freedom program, the training program in immigration law. The marriage immigration specific program is starting November 3rd. It's a 4 to 6 week course. And if it takes longer, that's why I give a buffer of 6 weeks, where I break down the marriage immigration process, the way I do it, the things I look for. And, it's the primary focus of my business and my law firm is a 6-figure law firm, pretty much just focused on marriage immigration cases. So I'm going to do that training, have many students already signed up who are learning this stuff. Some people are already immigration lawyers. Some people are new to it. So if you're interested in that, please email me at info@immigrationlawyerstoolbox.com and let me know, and I'll give you more information about that. We could even have a call so I could better explain and see if the program fits you or not. Secondly, one of our sponsors, Yotango Bot, I wanted to reference. You get a 2-month or 60 days free trial. If you have a website or a Facebook page or WhatsApp page and you can't get to all the messages or you don't feel like getting to them, our colleague Jared Jaskoff, fellow immigration attorney, created this bot where you could communicate, where people communicate with it, and the bot tries to get their contact info, schedule a consultation, maybe give videos you've done that answer questions. It just does that communication without having to hire a person or doing it yourself. So it's a really good thing to try out, especially because it's 60 days free. So one other thing I want to mention, and I'm really happy about this one, really proud, the company DocuWise, and I'm sure many of you are familiar with it, one of the top forms programs for immigration attorneys out there, contact me interested in sponsoring the program. And I was really happy about that because I've been using DocuWise for a long time. I've been on the month-to-month program actually for over a year. And not only was I happy about their offer to sponsor the program, which I accepted, but also it reminded me I'm on a month-to-month program. I would get a huge price break if I just made a year-long program. So that was saving money right there. But then when I was talking with them, I said, well, how could you hook up my listeners? And they said, on the annual plan, we'll give them an additional 10% off. In addition to the discount they get when they get the annual plan, they'll give an additional 10% off if they mention and go through the process of referencing the Immigration Lawyers podcast. So I definitely recommend checking this out. I've been using it. Their software is so easy to use. I'm going to talk more and more about the details of what I like about it in future episodes because it's just smooth. That's the best way I can put it. It's just a smooth running software. And it's an immigration lawyer that's running it, so they know what's up. Their person who's actually filling out the forms, the other co-founder, has gone through the immigration process himself. So Jeremy Peskin and James Pittman, two great people. I was really happy to get to know them and talk with them. The link for getting the annual subscription with a 10% off is docuwise.com/immigration-lawyers-podcast. Again, that's docuwise.com/immigration-lawyers-podcast. And the discount code is immigration-lawyers-podcast. So if you didn't get that, just email me at info@immigrationlawyerstoolbox.com. Not podcast, but info@immigrationlawyerstoolbox, lawyers plural, and let me know. I can send you the links to that. I'm going to go myself and sign up for the annual plan, which I should have done probably 6 months ago, a year ago, but I'm glad I waited to get that additional 10% off. And I do recommend the software. I do use it, and it's been such a smooth thing. So I'm happy to talk with and discuss it and just put the word out to y'all. And I want to appreciate Jeremy and James for working on this software. I know it's not easy creating this stuff, especially because the forms get changed like every 2 seconds. So running a company under an immigration company, as we all know, as immigration lawyers running immigration firms, under this administration is hell. But imagine having to get developers and having to update stuff, and they've been doing it. I haven't had any skips or delays and stuff in these updates on the form. So they have so much more going on with the software, which we'll get into. But again, it's something I've been using and I'm going to continue using. Just go to docowise.com/immigration-lawyers-podcast and get your 10% off code right there. So I think that's the housekeeping I wanted to mention. Just one last thing. If you're listening to this on iTunes or anywhere else, please leave a 5-star review and talk about why you like the show and love the program so other people could learn about it as well and listen to it. In the larger group we have, the better it is. As you know, we have a private Facebook page for immigration lawyers. You can join that. And I do all I can to share information as much as possible, both about changing laws, but also about marketing. I'm doing a lot of CLE sessions with immigration attorneys from across the country, sharing that information, sometimes giving free snippets of it, sometimes whole free programs for like a week or so. The Facebook page is the place to be, but you need to email me to join that at info@immigrationlawyerstoolbox.com. The email info@immigrationlawyerstoolbox.com. So with that, let's just jump into this interview. Welcome to the Immigration Lawyers Podcast, a part of the Immigration Lawyers Toolbox, an education and marketing publication for the immigration law community that includes legal updates, interviews, discussions, education and CLE material, and more. Note that the information here is for general education only and not intended as individual legal advice. The laws change frequently, so you should consult with an attorney about your specific case. For more information, please visit immigrationlawyerstoolbox.com. I have an RFE for an I-140, so that's annoying. Like, I didn't want to do it because it's such a waste of time. But it's a multinational manager, and the guy kept on salary on payroll at the foreign company just because he's an executive. And they're like, well, if he's getting paid there, how is he a full-time person here? Well, it's a bonus that they give him for what else do I need to say? Just because they want to.
Well, you're aware of the precedent decision matter of Pozzoli? Pozzoli, which says that compensation can be paid from abroad under the L1.
Yeah, exactly. They could, yeah. They had another part where they said, I already sent them W-2s, but they're like, you need to send us W-2s to show that he's a real executive. But I'm like, how's the W-2 itself show that? And then they have a generic language of my description was vague and broad. They didn't provide any explanation what was deficient other than saying it was vague and broad, which is against the statute. You got to give me something to work with so I could respond. So it's like 8 pages of garbage. I'm sure I'm going to get
I've responded to that. You know how I've responded? Maybe you want to talk about this because it's kind of fun.
Well, let's get into that. So let's have the intro, then we'll go, and then we'll introduce everything. Hi, everyone. Thank you for joining us on this podcast. I'm with Angelo Paparelli. We got started talking before the show started, but I'm going to continue it. And then, so we're going to jump in the middle of the conversation and go. It was about an I-140 I got from a multinational manager. It's ridiculous. Go ahead, Angelo, with your response to, I guess, set context of what we're talking about. I kind of forgot myself.
Sure. By way of introduction to the audience, I'm happy to be here. My name's Angelo Paparelli. I'm a partner at Seyfarth Shaw in Los Angeles. I've been practicing immigration law for some 4 decades, and I'm certified in the field by the State Bar California Board of Legal Specialization. So I am so delighted to be on John's podcast because John is an amazing entrepreneur and lawyer, and that's a rare combination. So to recap where we were, you indicated that you had received an I-140 request for evidence under the multinational manager category, EB1C, and they said paid abroad, and they said job description of the employment was broad and clear. and I have two suggestions on how to deal with that. I've encountered that very fact pattern. The first is to sit in one arena called Matt of Pozzoli. I think it's Pozzoli, easily found on Google. And it says it dealt with IBM, and IBM Italy and IBM US. And the petitioner in the US was IBM US. And they showed that for reasons of pension in Italy, they kept him on the Italian payroll. And the decision was that that's fine. The L1 does not require payment in the United States. Now, as a practical matter, that's fine for immigration purposes, but you have to be aware that IRS would consider that as U.S. source income. So there should still be a payroll tax compliance element to this. But the fact of the matter is they're completely wrong at USCIS in implying that payment abroad is somehow improper. Second thing about the duties are too broad and unclear or vague or ambiguous. I don't know if you designated this as a multinational executive or a multinational manager. Do you remember?
I always go executive route. I found I could work with that.
Okay, yeah, I think that's best, and that's why this fits. I go to the Homeland Security Act, and there is the definition of the position of the director of USCIS, and that lists a number of descriptions that are this director's executive responsibilities. And they are as vague and ambiguous and broad as you can imagine. So I cite to the statute and I say, this particular beneficiary's duties are far more precise than even your own director, but yet he seems to be performing his responsibilities adequately. So that's one way of doing it. Then I go into, I think it's the OOH. Yeah, it should be the OOH. And there is a description of what, yeah, I think it's the OOH. I can get back to you on that, but there's a description of what executives do. And there's an analysis that says executives do different things depending upon whether the job is for a large organization or for a mom and pop or startup. And for a large organization, the duties can be extremely broad and far-ranging because ultimately the chief executive officer does that which the board of directors instructs him or her to do based on the current business challenges and objectives of the organization to make a profit. So that's a DOL affirmation of broad duties. I still go forward and describe the particular responsibilities. And one of the things that I've done that I find to be very persuasive, and this is both for the position abroad and the position in the United States, is to ask the individual to go through their personal calendar, diary, whatever they do to maintain their appointments, and give me illustrations based on discrete activities or tasks. So I think people will, in these documents, show a particular function and then a percentage of time on average spent per month. Well, I then add underneath each task illustrated activities that are performed at the company abroad over a representative period of time. So who they met with, what they discussed, and I list that under each task. I do the same if they're already in the U.S. on an L1 and you're doing an I-140. What have they done in the U.S.? Illustrations based on their actual calendar. And I've found that that's pretty bulletproof in getting approved.
Yeah, I agree. It's agree. It's just, they just hassle you. It makes it like, it's made it so I'm really hesitant even accepting L1 clients because it's just so time consuming and frustrating for me to do it, which is probably their tactic. They try and frustrate the attorneys.
Well, it's a matter of pricing it properly.
Yeah.
And it's a matter of client management of expectations. And it depends on how you structure your practice. Some people have employees who can support some of that effort, and other people are essentially sole proprietors who do it all themselves. And so that means you have to be very choosy on what you expect, or be paid very well for each case you take on.
Yeah, and that's how it is. I'm a full solo, and with all the extracurriculars of the podcast, the toolbox, and this and that I do, and I've just so much passion to do this kind of stuff that I've kind of phased out. These are existing L1 clients I'm having, which we're walking through the EB1 route, and then new ones I'm doing consulting, whether attorneys contact me about L1s or EB1Cs, but to actually take on the whole case is just too much, even with the prices. I just enjoy doing these podcasts a lot, and it's.
Well, you're having too much fun, so we can't put you in the category of all the miserable lawyers like myself who have to deal with the frustrations of day-to-day rebukes from USCIS. I might suggest that there's one other solution, and that is engaging third-party writers who can be lawyers or paralegals under your supervision, and letting the client know that, so getting that sign-off on the engagement agreement, and let them do the drafting, and then you're just polishing it. If you've got a good quality team behind you, they don't have to be your employees.
It makes sense. It makes sense, because when it comes to one of the most important parts of these L1s, EB1Cs, is the job description, and for that, reviewing it and tweaking it is the most important part. So we don't say, because what I've seen is one word being off that looks like they're doing lower kind of stuff, like. Sometimes someone will write gathering information for a report. And it's like, well, it's CEO, you can't even gather information. They'll catch on that word, and or if you were deny it. So you have to make sure you are exact in your language, and that's what my proofreading would do. But have someone else do this stuff. But I do enjoy the direct relationships I have with the leadership of the companies. I just get a lot out of it. So I just get too deeply involved in my cases. But one note is with Matter Pozzolo, you mentioned about getting paid overseas. There was another matter, it was an L1B case where they said the income still has to be above the minimum wage and kind of makes sense in the U.S. That's a thing. But
that's true.
Now, you probably saw USCIS updated the policy manual for O visas today. I haven't had a chance to read it. Did you have a chance to look over to see if it was nasty?
And I likewise have not. I put it in my reading pile. There's so many things that happen every day. It's going to be interesting to see, because there already is a policy memorandum that interprets the extraordinary ability category for the EB1A immigrant visa, and that applies the Kazarian standard and a two-stage analysis. First, do you meet the minimum number of classifications or categories of evidence according to the regulations? And then what Kazarian was interpreted to allow was a final stage merits determination. I sort of describe this as like a dance contest. You can show that you've been in a certain number of competitions. You can show that you've been highly regarded by third parties, but ultimately you have to get out on the dance floor and show them that you can dance. I fundamentally disagree with that interpretation of the statute. And if this new O1 guidance mouths that, I would suggest it's a subject of litigation. I actually have a case in which I sued USCIS under EB1A, and darn it, if my beneficiary didn't get married to a U.S. citizen, and now they want to settle it on that ground. But I still have the argument, might be in the argument, because it could be used. It's a portable argument that can be used anywhere. Just to make clear, you have to have access to printed versions of interpreter releases, the old Bible of daily immigration law. And after the 1990 Act, there was an exchange of correspondence between the Nebraska Service Center and INS headquarters, and trying to understand how to apply the regulations, because there was a debate among the Service Center adjudicators. And basically, the question was posed to INS headquarters. The person that answered it was a fellow named Larry Weinig. Mr. Weinig essentially said, you make a qualitative determination under each category of evidence. Has it been satisfied or not? and if you meet the minimum numbers, that's the end of the analysis. The person is approvable. Now, that is completely contradictory to the Kazarian rule or a policy. And interestingly enough, not USCIS, INS, in 1995, I think the year was, published a proposed rule in the Federal Register, which would have, if it had been adopted, make the Kazarian interpretation, the final stage merits determination, part of the regulation. But the agency never adopted it. And so my argument was there was a policy. It had been publicly communicated. The regulated community relied upon that policy. And then all of a sudden, because of one decision that's not binding on the rest of the country, it's only theoretically applicable in the Ninth Circuit, they proceed to make it applicable as policy. Well, under my analysis of the Administrative Procedure Act, that is a legislative rule that has to go through notice and comment rulemaking. And when they decline to do that, they then are creating unfair surprise. They are trying to find ambiguity in a regulation where none exists. And then you can argue a recent Supreme Court case, a wonderful case called Kaiser versus Wilkie, which essentially says that there will not be deference, judicial deference, to an agency's interpretation of its own regulation if it is a novel regulation that creates unfair surprise, if there was reliance interest on the regulated community on the earlier interpretation. And so I make the point that some of the elements of the policy memorandum on Kazarian as to how you weigh the evidence is valid, but the final stage merits determination is completely contrary to the Administrative Procedure Act requirements of notice and comment rulemaking. So it's an argument that I'm looking forward to seeing the new guidance. I strongly doubt they will have embraced my analysis, but we'll see.
Why isn't there more lawsuits about this so we could get the record straight? Is it because people just settle most of the time, or?
I think there are numerous reasons, and in fact, I just was on a panel, a virtual Zoom panel for the Northwestern chapter of AILA in the Pacific Northwest, and talking about litigation, and so it's fresh in my mind. Number one, companies are extremely timid to put their name on a complaint where they are suing the United States government in an immigration matter. Sometimes they are timid because they are federal contractors and they must list any litigation they have with the federal government, and they don't want to lose their federal contracts. Sometimes they are timid because the media gets hold of the fact that a complaint was published, and somehow it's thought by a segment of their consumer base that it's unpatriotic to sue the federal government. Now, they don't feel this way in environmental litigation and in SEC litigation. They're happy to sue, but for some reason, immigration is sort of a hot potato. On the side of the beneficiary and the company, there's oftentimes a fear that this will lead to retaliation or it will lead to unwanted focus and attention. And I'll address that, and then I'll talk about why little lawyers don't sue. There is a technique to avoid publicity. When you file a litigation in the federal district court, you're required to fill out a civil cover sheet. And they vary from district court to district court, but generally speaking, there are two options to check as to type of lawsuit. One would be Administrative Procedure Act, but the other would be immigration. And if you designate it as immigration, it actually says immigration or bankruptcy. But that box, if you check it, will cause the pleadings to be sealed. And so only the lawyers for the parties and the judge get access to the records. So let us suppose you're suing the service center and you're suing USCIS, and you're suing DHS. Or let us suppose you're suing Chad Wolf or Ken Cuccinelli. If you put your individual beneficiary's name in the caption of the complaint first, and then the company name, it will come up, and then you put the surname of one of these officers, then the agency or department name, it will come up on the cover sheet as, let's take Chad Wolf, Wolf et al. V, the beneficiary's surname et al. And that will create a level of anonymity that nobody knows. Now, another reason no one wants to sue is there's a fear that this will be costly. And whenever you do something the first time, it takes longer. But once you have done it a few times and you have templates and you get involved with the resources of the AILA administrative or AILA litigation task force, you'll have quite a bit there. Now, why don't the lawyers sue? The lawyers sue because it's outside their comfort zone and they don't know that they'll ever get paid and they fear that it's too much work. But what they don't recognize is, unlike regular civil litigation, there's no discovery. It's just the administrative record. And you already know what the administrative record says. So you file a complaint. Maybe there will be a motion to transfer venue. Maybe there will not be. Maybe there will be a motion to dismiss. But certainly you will want to file a motion for summary judgment and oppose those other motions. But ultimately, you're doing a complaint and essentially, as if we're the same thing, an appeal to the AAO. You're just writing a brief as to where the agency's mistakes were, why the agency's conduct is arbitrary, capricious, an abuse of discretion, or otherwise unlawful. And fortunately with this agency, there are numerous circumstances where that behavior is easily proven. And what I have found is that filing the lawsuit will enlist an advocate to help you deal with the problem, namely the assistant U.S. attorney. A lot of lawyers think that the Office of Immigration Litigation in Washington, OIL, will be the agency that you'll fight against, and they're immigration experts, and so it'll be really hard. But OIL doesn't get involved in individual cases very often. They get involved in big cases, such as border disputes, or is the Dreamer executive order valid or not valid? So you're going to deal with a lawyer who has other things on their desk and who has the ability to interface with the regional counsel of USCIS for the service center in which the decision was made. And so the assistant U.S. attorney doesn't want to deal with a lot of work on a case that looks like it will not prevail. Some are more deferential to their internal governmental client than others, but many times you can work out an arrangement. Sometimes it's a remand and then you respond to an RFE and you get approved. Sometimes they just approve it. Sometimes you negotiate an alternate settlement. But the fact of the matter is, you have a way to interface with a real lawyer who will treat you with respect and may help you get the benefit that you want for your clients. I've been doing more and more litigation. I wrote about this on my blog, nationofimmigrators.com, and you can find it if you just Google Paparelli blog or Paparelli immigration blog. And it's called Sue the Miscreants. And I talk about why you should be willing to sue and what you should be doing to get your case ready so it's in a litigation posture. As you know, the agency is in a big fight right now over increasing their filing fees. And they can't afford to spend a lot of resources issuing stupid decisions if they have to litigate them, defend them, and they ultimately approve them anyway. There's a limit because of the announced furlough or threatened furlough, and then all of a sudden, oh, we're not going to furlough, we've got enough money. Oh, maybe we don't have enough money to the end of the year. there's a lot of eyeballs in Congress on how the government spends money within USCIS. And I have an interesting amicus brief I did last week that I'm really excited about. Next Friday, not tomorrow, but next Friday, it will be heard as part of the Immigrant Legal Resource Center litigation against USCIS over the fee rule, the filing fee rule, which, as you know, takes effect in the beginning of October. And their AILA is seeking to get a preliminary injunction to prevent the activation of these higher filing fees and these changes in forms. And so I wrote an amicus brief on behalf of a think tank, a mastermind group that I created called the Alliance of Business Immigration Lawyers, ABLE. And we argued, I'd done a law review article on it a year or so ago for AILA, but I argued in this brief, and I should give credit to my colleague at CIFAR, Stephen Malm, we argued in this brief that the Fraud Detection and National Security Directorate, FDNS, which conducts all of these unannounced site visits and makes petitioners' lives unpleasant and sometimes lead to issuances of notices of intent to revoke petitions that are already approved, that FDNS is an illegal organization. Somebody joked with me that I should have used a RICO claim, that it's a racketeer influence corrupt organization, because it is a violation of the Homeland Security Act. Now, it's not a criminal violation, so I don't know if it would work under RICO, but the point is, under the Homeland Security Act, Congress absorbed a lot of preliminary experience and oversight hearings that the old INS was not functioning because it had inconsistent missions. On the one hand, it was the benefits adjudication agency, and on the other, it was the the investigations and intelligence gathering agency. So Congress in the Homeland Security Act said, these functions shall now be separate, and ICE is responsible for investigations and intelligence gathering, and USCIS is only responsible for the adjudication of petitions. Now, my brief said, apply common dictionary definitions of these terms. To adjudicate is to act as a judge in an impartial way to make a decision, whereas an investigator goes wherever the facts lead him or her, and they don't necessarily have to determine whether the evidence would be admissible in court. They just gather information, and then they use that information possibly to initiate civil or criminal fraud prosecution. And so those functions are separate. Congress intended them to be separate. And so any money spent by USCIS out of the immigration examinations fee account, which is dedicated to adjudications, cannot be spent for enforcement, for intelligence gathering. And so I'm really excited to see the court's outcome on this one, because I've been arguing that FDNS is illegal for a long, long time. And I'm sort of like a Don Quixote screaming in the wilderness, but we'll see what happens.
It's just madness that they say we don't have enough money. I mean, it's just with the things that they're doing, probably they don't, because they're just blowing through so much money. I mean, look at all the bogus RFEs that are being sent out every day, constantly. Yeah. I mean, I'm getting so many about birth certificates we sent, about I-64s we sent that they said were not submitted. And it's like, it doesn't make any sense. How much does it cost you to constantly do this back and forth millions of times?
Yeah, the General Accounting Office, I've been observing, my blog is subtitled America's Dysfunctional Immigration System, but the USCIS is probably the most dysfunctional of all the agencies, and that's high praise or high demerit, because all of the agencies are more or less dysfunctional. But USCIS has had since 2006 an effort that they have called transformation, that has stopped and started and stopped and started, and they have this ELIS, electronic information system, that is supposed to allow you to be adjudicating online with everything submitted in terms of evidence as attachments. They tried to do it with the NATS petition. They tried to do it with the I-539. I lost a big client because I trusted that it would work, and it was an abject failure. They tried to do it with the EB-5 category. It has not worked. And just a week ago, the GAO wrote a report that talked about how much failed effort and money wasted has been on transformation. And it's exactly what you say. If you've submitted a document, they should have electronic access to it. The whole premise on why they don't allow deference to their prior approvals when there's an extension of petition validity and status for somebody already approved is that the paper record is in salt mine below the state of Missouri, and it's too much trouble for them to pull up the paper record to see what was said the first time, and therefore you have to prove everything fresh the second time. They don't trust a word. But if everything was digitized properly, I mean, you're a law practice technology maven, and you know all about this, it would be so much easier. And yet, and ironically, with COVID, they're working remotely now. So it's in their benefit to be able to do this. The one silver lining is that they've been waiving interviews and waiving biometric appointments because they realize they can pretty much adjudicate things digitally without physical appearance.
It's just a headache that they're doing with that. I mean, speaking about biometrics, I've been getting EADs without it. But as you know, there's a proposed rule to make biometrics so burdensome, I think, to really halt the ability of family-based cases to move forward. I really want to sue them on this idea that a U.S. citizen has to do a vocal scan and an iris scan to be a financial sponsor. If that makes any sense, is there an argument that makes sense for that that I'm not aware of? Why a U.S. citizen sponsor would need a voice print and an iris scan?
Well, if you have to if you sell your house or you refinance your mortgage, a notary will come to your house and take a fingerprint. But they don't take an iris scan, and they don't take a blood sample. And so I do think there's a lawsuit there, but I don't know that you're the one that wants to devote all the resources to win that lawsuit. I'm hoping the ACLU will take it up, or the Electronic Freedom Foundation, because this is a clear invasion of privacy. And where does this data go? And is it ever going to be misused by some hacker?
My opinion is, immigrants are, the Jews of World War II. It's an easy way to get all the, police state stuff in, as we see with ISIS actions, as we see the internal border checkpoints, all that stuff. So it's turnkey totalitarianism, as they say. So we have everything set on the fear of these immigrants. Even Trump's ex-wife came on TV and started talking about immigrants being rapists and stuff. I can't believe an immigrant would say some crazy stuff like that. But I think it's their way of getting things in place if needed, because it's just so ridiculous, the over-the-top fear-mongering and mechanisms they're creating to try to get a population who they say is 20 million here. If immigrants were that much of a problem criminal-wise, we'd have massive mayhem right now in the country with 20 million people plus that may not have a status. So that really worries me. It's one of the things I would like to do in the future is just get involved in these kind of civil liberty kind of lawsuits, which is one of my passions. Having been to Iran and having seen what's going on in countries that don't have civil liberties, that's all we have here that keeps us safe. So it's a personal passion.
And I agree. I mean, I heard a horrific thing yesterday that if Trump is reelected, Stephen Miller is going to be appointed the Secretary of the Department of Homeland Security. So if you really want to have some nightmares, think about that, because he's had his fingers into every one of these draconian measures behind the scenes. But if he were actually the secretary, I fear for the republic.
It'd be over. I mean, it's all downhill from there. A couple of points you brought up. One about the interpreter's release, and I'll be reading Kurzman, and he'll cite the interpreter's release, and I'm like, where is this document? There's some book that's like $5,000 I have to get access to these, but is there an easy way to access these, or is it just if you had them, you had them?
You go to a public library. Most public libraries, or law libraries, I should say, have these. Now, let's hope they haven't dispensed with them. If you need a particular issue, I have a collection, and I know other lawyers that have collections. So you just find some senior immigration lawyers who are pack rats and beg them to send you a scan of a particular page.
Awesome. Yeah, it's so important because there's like I had one where if an F1 student visa holder is in their grace period, can they do change of status or not? And the regs are like all over the place on this. I would say the answer is yes. But Kurzman cites to an interpreter's release. And I was like, I really need to see exactly what it says there because it's kind of ambiguous in some parts of the CFR where they describe whether you change of status or not. And, ICE and their study in the States or CBIS website kind of says you can. It's not clearly written. That's just one of the many times interpreter releases came into place.
Yeah, let me mention that it came to play, and I sent the particular article. The former INS General Counsel who passed away, Sam Bernson, who was the final name on the masthead of the Fragament firm, wrote an article about all of the ways in which the old INS had granted employment authorization, whether explicitly supported by act of Congress or just in the exercise of the agency's discretionary authority. And that was published in interpreter releases, and I had saved a scanned copy of it, and I sent that on to the litigators who are trying to protect against the loss of employment authorization, non-statutory employment authorization, which the Tech Workers Alliance is seeking to do, starting with F1 students, but probably it could have consequences far more broad.
I'm sure they're trying to get rid of H4, which that litigation is going on for years. And there's this mess of the E2 dependent, if they need work authorization or not. Social Security Office says they don't. There's a CFR has a miswritten part of it that kind of says they don't. And so it's so annoying that these dependents have to apply for work authorization.
There's also a non-precedent decision of the BIA in this area where it says a person can adjust status because in the case of the E2, and the same theory would apply to the L1, the L2 spouse, it's a statutory grant of employment authorization. The EAD is merely a physical manifestation of the existence of that right, but it is not discretionary in granting employment authorization under that circumstance. So, interesting issue. I've dealt with it a number of times, and I've usually been able to persuade an adjudicator at the adjustment interview that that's the case by using the non-precedent decision.
You have to have knowledge.
And the Social Security Administration says it as well. It says that if you have proof of a DHS authorization, you can issue a work authorized Social Security number. And the DHS authorization for an L2 or an E1 or E2 or E3 dependent is the admission stamp, the I-94, that they were admitted in that classification, and a marriage certificate. So it can be done.
Exactly. And you know what obnoxious thing is when you're doing pre and processing now, they won't adjudicate the dependents and their work permits at the same time anymore. So they're just waiting and waiting. It's just so obnoxious. They changed that. They want to make pre and processing, I don't know, 30 calendar days or some ridiculous aspect that just it's not even premium anymore. And they're increasing the fee at the same time. So what a organization. We increase the fee, lower the service, and we still give you our fees to just drag things on. It's so ridiculous. Angelo, could you still contact USCIS and ask them for opinion letters on things, or is that not possible? I see in AILA's listserv where they have old ones where they'll write letters and the counsel for the US respond.
The whole liaison function has been shut down within USCIS. CBP still has a liaison function at the chapter level, and I think the State Department still has a liaison function where what sufficed instead of a legal opinion or advisory opinion was official minutes. You can still get an advice letter from, for example, the Department of Justice Immigrant and Employee Rights section. They will give you an advice letter. There is an advisory opinion concept within the Department of State, but those are never published because it's a private discussion, the way the department describes it, between the State Department and the consular officer. So you can request an advisory opinion and you won't know what the opinion is, but maybe you win your case. And so it's very, very opaque around the Department of State. The sense of an advisory opinion is dying as long as there's no liaison function, and as long as we're litigating them all the time. They don't, suing them all the time. They don't want to be publishing their opinions and then be sued over them. Yeah. But there are other agencies that issue opinions. I mean, the OIG wrote an opinion about whether acting Secretary Wolf and acting whatever Ken Cuccinelli is were lawfully appointed under the Vacancies Act. And so there are opinions that get out there. They're just not coming from USCIS.
Mm-hmm. And it really is whatever when it comes to their title. It's such a travesty to have these kind of characters running this game. Now, having been a person who's been practicing, for decades now, you were there in 1994-ish or 1990s when IRA came. What was the mood then? Is it comparable to now? I'm assuming it's much worse now. But what was going on in people and practitioners' minds? It wasn't online communications like we have Facebook groups right now where the mood really gets there. But from your going to conferences and talking to colleagues, how did it feel back then?
Well, a little bit of history. First of all, unfortunately, this came down during the Clinton administration. One would have hoped that it would not have occurred, but it happened by the virtue of the House Immigration Subcommittee chair, who was a Republican, but he really felt that it should be much tougher on unauthorized immigration. And originally, IRA was a much stronger bill that would have drastically reduced legal employment-based immigration benefits. And what history showed was that there were advocates who argued split the bill and deal with illegal immigration alone, and then come back and deal with legal immigration later. Well, they did split the bill, and that split the AILA community because advocates were on both sides of that issue, and it was quite argumentative. But the ones that said split the bill because they didn't want legal immigration impaired were kind of blindsided by the unlawful presence provisions of the statute, the visa avoidance and the 3 and 10 year bar, because that was left in, and they didn't realize that that would come back to bite them in numerous ways and raise the risk of noncompliance, of unauthorized employment tremendously. So it sort of taught me the lesson that be careful what you ask for, because if you don't have solidarity with the immigrant stakeholder community generally, there is a big chance that you're going to be hurt. Maybe not immediately, but ultimately. And we're seeing this right now with the Fairness for High-Skilled Immigrants Act and the desire to create equity for persons with backlogged immigrant visa quota priority dates, and saying that those who are not in backlogged countries are going to be disadvantaged. So there's arguments on both sides when really the debate ought to be, we don't have enough immigrants in this country. We don't have enough legal immigrants in this country. We're facing a demographic shortage. Social Security is going to go bankrupt because people of my generation are going to retire and ask for benefits, and there won't be enough young, vigorous fee earners to pay those benefits. So there's got to be a new debate around immigration. And I'm not even sure that in the context of a post-COVID world with high unemployment, the circumstances are such that there will be a positive discussion of this. But I'm not an open borders advocate. I really do believe we have to have constraints, but we are losing out in global competition with the likes of Canada. Canada right now is eating our lunch with all sorts of attractive work visa options that don't exist in the United States. And even the Biden administration's platform has a new way of looking at the value of H-1B workers and preferring those with higher levels of education, higher wages, over others who are entry level. And that doesn't really make good sense, because you can't have only Einsteins working for companies. You've got to have talented entry level professionals who are going to be paid entry level wages. And if you don't allow that, you're hurting the country. Mm-hmm. So if you're a student of history, these debates are not new. They've been going on for a very long time. I recently read a book by a woman named Iris Wilkerson, a former New York Times reporter. She wrote The Warmth of Other Suns, prize-winning book about the great migration of African Americans from the South to the North. But her latest book is called Caste, C-A-S-T-E. And it compares American history with the history of the country India and Nazi Germany. And it talks about how the laws and the constraints and the restrictions were recurrent in the three countries based on patterns where persons were low caste or high caste or upper caste. And it's not always racial. There have been Southern statutes that said 1 drop of African American blood was enough to make someone African American, as a means of keeping people out of upper caste opportunities. And so immigration is the same sort of thing. There are opportunities for historic prejudice, abuse, and we're just seeing it again and again and again. So what's the solution? People have to stand up and oppose that.
Yeah. Since Trump came, and I'm a small scale firm solo, I've had millions of dollars of investment that for L1s, E2s, even E5s that can't come and do the investment. And so this idea just of taking away jobs is frivolous. Now, on the other end, you have to have a mix of people coming in. You can't just go for a certain echelon of society. It has to be balanced, because so many of the people who come here, I started a nonprofit foundation called the Migration Foundation, which is going to highlight just information about global migration. And so I have like an editing team video now. We're doing shorts on just short clips of people who were immigrants or their parents were. And it's just like all the leadership of the major corporations, all the new technology, 9 out of 10 times is that high is going to be foreign talent that came here or their parents came here. So it's just like, I think when we're talking about a world where China might be overtaking us, China is a society that doesn't let foreign people come here. Xenophobia is part of their tradition. And so you're either Han one day or you're not. And I think that's always going to hold them back from being a global superpower, because every major power in history of the world, from the Persian Empire to Rome to England to United Kingdom, they've always had not open, but at least openness for the migration of people and talent and just that energy that to come in that's fresh. And so if we don't bring that in, China is going to eat our lunch, because that's the upper hand that we have from China, is that Chinese people want to leave China to come here because they realize the freedom that exists here, for freedom of thought, life, and that lifestyle. Just the idea they could have 2 kids instead of 1 all those years, where they dramatically, curtail their population like that. So brutally. It's mind-boggling, but it is this back and forth that you see it happens with society. One of the reasons I like this discussion, the migration on it too, is I think people, if they talked about it, we could have a better solution rather than these wild swings that happen. When people don't talk about immigration, then when it comes up, it's like crazy swings on the pendulum of extremes. There has to be a discussion, because although I would like, immigration numbers to be the same and more, business-based immigration, which is my focus, there are people who don't like that, and it is their country too, so they have to have a word. But the best thing is have a discussion to understand where they're coming from and find ways, if possible, to satisfy as many people to keep this engine going in this country. Because I don't think Stephen Miller's idea of future America is going to take America anywhere other than a ditch.
Well, this whole concept of American exceptionalism is something that I've always had trouble with, except with respect to immigration. That's what has made us an exceptional nation, is that we've replenished our energy with fresh creativity. And I mean, the story's been told so many times. Steve Jobs, the founder of Apple, was the son of a Syrian refugee. One of the founders of Google was the son of a refugee. Actually came here as a refugee himself. I can't tell you the number of times I've encountered people who are lottery winners and really successful contributors to the United States who would never have come in under the normal system. So that's the interesting part about our immigration system, is we don't have the wisdom and ability to figure out who should be coming. I'm sort of opposed to a merit-based system in one respect, because it contemplates that some level of commissar or economic planner can figure out what we need, when what we need is to just sprinkle the system with very smart and creative and energetic strivers and creative strivers, and they'll do it themselves. So I'm more in the nature of recognizing that there's magic to this stuff as opposed to science. And I saw one thing in the Biden platform that I did like, and it's an old Republican idea during the Obama era that started, I think, in Michigan, and that is that a governmental officer at the local, regional, or state level, an economic development organization, can designate and earmark a certain number of entrepreneurial visas or job creation visas, and create a process to award those. And the only role of the federal government is to vet security threats or criminal background. I like that idea. I think that there's sort of like that in the doctor waiver area, but it could be really an advantageous thing, not because the state or local authorities are smarter than the federal, but just because the whole idea of the states being social laboratories and seeing what works. To me, we should be really creative. And I, for example, would never qualify under one of the point systems because I'm too old. So arbitrarily, I'm knocked out. But I have a few ideas to contribute, and I could be advantageous to one of these other countries. I'm not planning to move, but what I'm just trying to say is there's a certain arbitrary element that an economist, a sociologist, a government bureaucrat decides, well, what kind of people do we need? They don't know any better than any of us do.
It's going to be lopsided in some direction if they do that. It's going to take things in the wrong direction. And also then it's going to lead a lot of gaming the system to try to match that, which always happens, instead of just being open. The diversity visa, which is something you're trying to get rid of. And, at first, before I got involved, it didn't make much sense to me. It's kind of random. But the more and more I've had clients who have diversity visa, usually in the naturalization setting, that they come to me. And I learn about them. I'm just like, wow, I'm so happy they won the green card lottery. This is exactly the kind of person.
Right. And I feel the same way. I mean, the whole history of the diversity visa was to help the Irish. Senator Kennedy came up with this. And then it got expanded to those who were underrepresented in the usual system. And I thought to myself at one point, and I'm completely changed on that now, that it was sort of an abdication of governmental responsibility to decide what's best for us. But I've now reached the point where I don't think the government or private sector alone has the smarts and the skill sets to even know what's best for us. Who is the next diversity lottery winner who's going to come up with the COVID-19 vaccine? We don't know. We don't have that capacity to decide, unless we're going to turn it over to AI and have IBM Watson decide who's going to come in. I think we have to do our best to try to have various ways. I mean, look at the H-1B category. Where did the number 65,000 come from? I challenge anyone to tell me. It was just pulled out of thin air, and it still applies. And so why is that a logical way to put a limit on smart people? I mean, Bill Gates once said, and I quoted him in one of my articles, that it's really dumb to put a quota on how many smart people we can have in this country. I mean, it just really makes no sense.
That's funny. That's true. That's true. That's it. My idea is like if someone does come on the H-1B, ends up, EB-2 or something like gets a green card, they're usually going to end up starting a company, hiring more people anyways, or they're making so much money, they're going to go out spending the money. It just doesn't make any sense to try to curtail talent from coming in, or even above when it goes to not just looking at education or skills. It's the people who are willing to make the trek out here. It's, I hate moving. Every time I have to move from Brentwood to Encino, where I moved, which is 4 miles away, I was dreading it. Moving from another country here, that itself shaves off 99.9% of the population, because even if they want to come to the United States, they won't do it. There's cases of people.
Well,
yeah, it's just too tough.
I commiserate with you because I know that 405 can be murder driving from Brentwood to Encino. But for those out of towners who might not realize that, I make that point. I agree with you completely, and it shows an element of risk taking, and that brings to my mind the notion that entrepreneurship is discouraged under the current structure of the immigration laws. There is no entrepreneur visa. There is a theoretical entrepreneurial parole visa, which was a terribly architected solution because it was so complicated and so full of skepticism of entrepreneurs and requiring VC endorsement, and yet you can't do a self-sponsored labor certification. You can't get an E2 into a green card status under the current rules unless they find a friend to sponsor them, and it's all very contrived and unnecessary. And so we really have to take a fresh look, and I'm afraid no one's taking that fresh look. So that it's just we'll continue to just muddle along at best. I hate to be a downer, but that's probably what will happen.
If I'm not sure how much time you have, I'm down to keep talking. Just let me know if you need to go or drop. But I mean, when they talk about immigration reform, one, it's kind of scary to do it now because you don't know what kind of madness they could inject from the administration into it. But is it possible to do comprehensive immigration reform? Because there's just so many categories and so many, admissibility statutes and stuff to fix that. Is it impossible? Because like every time they adjust, let's say they do comprehensive immigration reform, the focus is always going to be on the border and stuff. What's going to happen to L's? And is that going to get lost in the mix of how ridiculous this statute is about the definitions of a manager? Or piecemeal do it, but is that piecemeal always going to, you fix one thing and another thing breaks? It's kind of like fixing a plumbing of a house. So you just gut the whole house and put a new system in. And is that system going to work, or you just piece by piece do it?
Well,
fix it.
I think that there are some historic examples of what might work. I would suggest that if there could be agreement around the appointment of an independent commission, Barbara Jordan, a former senator, a representative who was very active in immigration, led a commission. There have been military-based closure commissions where very political decisions had to be made. But they probably are not best done in Congress. So if you could have trustworthy, right people sitting at the table on a commission who would have to work through the entire system and then come up for an up or down vote, I think that may be one way to do it. But to try to do horse trading in Congress, it's always been a mess. There's very few things I agree with Justice Clarence Thomas, but he did say something recently in an immigration case, the Dreamer case, where he said immigration law is perhaps the most obscure and complex area of administrative law among all of the fields of administrative law, and I think he's right because it touches every element of human activity and human behavior. And so how do you get Congress to cover all of those broad-ranging areas with so many constituencies and try to reach harmony? It's a fool's errand. So I would be more inclined to a commission as long as there were some real strong protections that voices would be heard, and that it would be science and metric based as much as emotion and people centered.
You have much more faith in the system working properly. I don't know.
I have no faith in the system working. I mean, I'm telling you what I as a person who dreams, would dream to be a solution if I were God or king, and I'm not.
Yeah. What were your thoughts on that, Dr. Decision? I'll just briefly say mine. I think dreamers should have some sort of path to citizenship. It just kind of makes sense to me. Very controversial in some sects of the country. But the way they made the decision was disturbing to me, because they opened it up so that you could always stop. Like they said, the president didn't do the APA process properly. It opens it up where later, if let's say Biden comes in and wants to undo a travel ban, that a district court could say, well, you didn't undo it properly in the APA, go do it again, and really close that path for president if they put it in to take it off. So I wasn't really happy with the reasoning. It was kind of forced, in my opinion. But what are your thoughts of how they made that decision? Because
I don't think they had a clear majority for affirming the executive order, and it's ironic because they did affirm the travel ban order. But the sense I have is that what Chief Justice Roberts did in writing that decision was to provide a roadmap to an agency as to what is required to revoke an executive order. And I would imagine the Biden administration, if Joe and Kamala are elected, will follow that roadmap as closely as they can and make sure there is adequate consideration of stakeholder reliance interests and a reasoned interpretation and an articulation of why they're doing it, and do it in a way that would allow it to be revoked if it should be revoked. I mean, the growth of the executive branch and the power of the executive branch in the face of a Congress that can't agree, and in the face of what looks to be a changing philosophical direction of the judiciary with all of the Trump-McConnell appointees, it's going to be scary no matter what happens. That'll be something that lingers for a long time.
One thing that's interesting in immigration in federal courts is that sometimes you never know which way a federal judge will come in on immigration specifically, even though if they have a conservative bent. So every once in a while we'll be surprised about that. But speaking of the power of the executive branch, one topic discussed between people who are into immigration law, I think I read one of your articles, you mentioned it, but the power of 212F and the ability of a president to unilaterally make a decision when it comes to travel bans as part of the purview of their decision making. Would that be something that would need, in a fixed immigration system, that would need some better explanation, or would it be an executive order? You might need congressional acceptance of that. Is that something you want to redo?
I think definitely, because the way the statute reads now, the president has to make a finding, and it doesn't specify what it takes to make a finding, and it doesn't specify the subject matter of the proposed or perceived harm to the U.S. in order to make a finding. So should it be solely foreign policy findings and no domestic economic findings? I think that's the case. If you read Judge Mehta's decision in the case where the diversity visa lottery ban was overturned, but everyone else was, all the other bans were affirmed in terms of the president's power, you can use that as a guide to how to fix 212F. But 212F is really overreaching. It was meant to be in a true emergency situation where things had gotten out of hand and Congress couldn't act quickly. And it's become an all-purpose alternative to legislating. I almost think it violates separation of powers because what has happened in the last 6 months, and I'll tell you from my own practice, I have gone from filing petitions with USCIS to filing requests for national interest exceptions to the bans, the geographic ban and the labor market ban, to consular posts and to CBP. And there are no regulations around what it takes to approve it. There are guidance documents posted by the Department of State. There's virtually nothing posted by CBP, and they're ruling by the seat of their pants in a geographically dispersed way across all of the consulate posts and all of the ports of entry. And they just opened up all of the ports of entry to entertain these requests. It had been 15 airports only. So we are operating in a Wild West environment of no body of law. Throw yourself on the mercy of the adjudicator, who doesn't normally adjudicate these things. And even more absurd, they get no money for it because there are no filing fees established for these exceptions. They're just requests, and they're expected to adjudicate them in order to show the judge that they have exceptions to the broad statutory 212F authority. Doesn't make any sense. No way to run a government.
Because these are both agencies, both CBP and Department of State, DOS, and the consular system that are massively understaffed, massive hits to their,
right.
They just already don't have enough money, don't have enough manpower. They're frustrated because I've met a lot of good people at CBP and at state, and it just, a lot of them are leaving because it's just like, why do this? There's
right.
It puts a lot of pressure.
Well, I frankly would go back and say it's time to rethink the Department of Homeland Security, the Department of Justice, the Department of Labor in their overarching role within immigration. There are too many cooks in the kitchen, and they don't often get along with each other, and that's why too many cooks in the kitchen spoil the broth, as the saying goes.
DOL, their stuff too to make things more difficult. Steve Miller's team got involved with that. They're updating different regulations for DOL. But sorry, go ahead.
Well, my point was that we don't even have an independent immigration court. And I'm not just talking about removing the immigration judges into a Title I a court under the Constitution has been proposed. But I was a while back involved with the Federal Bar Association. We wrote up a proposal that was broader than just moving the IJs to do removal hearings into the Title I independent court, but to have all immigration legal decisions decided by a single body, and not the AAO and not the BIA, but a court, so that there can be a jurisprudence that is created to allow for lawyers and the public to know what the law is. I mean, it's absurd that I have been appointed an expert witness to say what the immigration law is, because the law is so opaque that judges who do not practice in immigration and civil litigators or criminal litigators who do not practice immigration can't make hide nor hair of it. It's just absurd that there's no order and logic to the system. In fact, I almost think you should give me a transcript of this conversation, and we'll put up together a proposal for immigration reform.
I love it. You have written something, you have had a discussion with another attorney about what is unauthorized employment, because we still don't have a definition that's really concrete about, if I'm here and I work for a foreign company, does that count or not? Is that a violation? And I remember reading it back and forth. You have another attorney about that. It's such a mess. But one thing they're doing, and speaking about jurisprudence, it really annoyed me. Well,
let me just address that point because it's really relevant now with COVID. And my good friend Cyrus Mehta just wrote a blog post a week or so ago on this same subject, that in a mobile world, especially when people get stranded by a pandemic in a country not their home country, and they have a laptop, are they breaking the law of the location where they happen to be by responding to emails from their employer abroad? It gets into really interesting questions of the extraterritorial reach of the immigration laws. I've looked at that. There's also fundamental questions of comity between countries, because if Brazil starts saying an American sitting in Brazil accessing their system while in Buenos Aires, or excuse me, that's Argentina, Rio de Janeiro, is breaking Brazilian law, and they start putting Americans in jail for that, well, then we've got retaliation all around. So there's got to be some sort of global accord as to what's allowed and what's not allowed. But we don't live in an age of globalism anymore. The UN has fallen out of favor. NATO has fallen out of favor because of what's happened in the Trump administration. And so there have to be some bright lines developed as to what is permitted when you're in another country, when you have a job and you're working virtually. You're not threatening a local labor market when you do.
Yeah, and it just advising people on that situation is such a nightmare. And I have to be safe, take a conservative route, which affects people financially, affects their companies and stuff. It's such a mess. But another thing is regarding jurisprudence and development of just case law in immigration. They historically, the AEO would list their unpublished decisions in order of as they're coming now. And I would read every single one of them for L1s, EB1Cs, as well as other ones. They updated the website, so now it's a search box for you to find these decisions. Well, I've been downloading every single decision for a long time, so I have a database of this. And for example, if you try to search for all the L1, EB1C decisions for I-140 and I-129 for L1s and whatever in January 2020, they don't all come up. So they're hiding AEO decisions in there. And it's so troubling. I sent an email to the ombudsman because I don't know who to contact about this. They said I need to fill out the form as if a client is. I'm going to contact congressperson.
Don't waste your time. Let me offer a couple of suggestions. One is quick and easy. Google accesses those decisions if they have been published. If they have not been published, you should be filing FOIA requests. There is a fellow named Matthew Hoppock, Hoppock, who has done amazing things, filing FOIA requests to the EOIR and coming up with emails and all sorts of stuff. And so we ought to get him to train us on how to regulate the AAO. That's another juridical body that gets under my skin, mainly because they claim to have the power of de novo review. And that means they're not an appellate body, but they also have a line of communication to USCIS policy shop. And so there's ex parte communication going on. So where is the due process in working with the AAO if they can undermine what the regional service center has said or the district office has said, come up with a completely new ground of denial, enhance a denial so it's harder to litigate, and they have ex parte communications, plus they don't publish their cases. This is not a court. This is not a tribunal that is abiding by any sense of administrative due process.
Well, in the proposed rule change for AEO, they said de novo review is completely going to be gone. If you don't make an argument initially, you can't bring it in. They would sometimes allow new evidence come in. That's gone. The AEO is pretty much completely worthless if these proposed regulations already how much value it has. So federal litigation is the only way to move forward. It makes no
right. And I unless the client insists on going to the AAO, I go straight to court. Yeah. And I've had much better results. And, a U.S. attorney is required to answer the complaint in 6 days. 6 days is a lot faster than the 180 days, which is the target for most USCIS decisions. And when they answer, they usually will up with something. Maybe they need a little more time, but they're asking you for something. So you ask for something back, and you're dealing again with a lawyer who you can talk to as a human being, with a colleague at the bar, and try to get a solution.
Mm-hmm. Yeah, even I've had case AO approve the case. To get USCIS to actually move on it could take extra months. And I've had companies go out of business by that point, where they're just like, we've been waiting, just to get the initial L1 denial took forever. Then AEO approves it. By the time USCIS comes to do it, they're like 1 year where their executives have to close up shop and leave and just destroy the business and destroy a lot of jobs in the US. Angelo, I'd love to have you on more often because you can tell I love talking about this stuff.
Sure.
I'm an immigration guy.
I do too.
So we'll set it up, and any particular topics you want to bring up, let me know. We'll discuss that. And I'll do an intro that talks about why we jumped into this a little better. But I think we use the time wisely to talk about stuff we like to talk about, and the listeners do too.
I enjoyed it. Thank you very much.
Thanks, Angelo. I'll be in touch. I'll have your information, the show notes, people get you and everything.
Yeah, circle back with me on how this is going to be available. I'd like to link to it in social media.
You got it. We'll do.
Okay, thanks a lot. Bye-bye.
La